030 of the Metropolitan Code of Laws, please take notice that decisions of the Metropolitan Government of Nashville and Davidson County Community Oversight Board may be appealed to the Chancery Court of Davidson County for review under a common law writ of cert. Any appeal must be filed within 60 days after entry of a final decision by the board. Any person or other entity considering an appeal should consult with an attorney to ensure that time and procedural requirements are met. I think the only update I have is I sent the letter that the executive committee charged me to send to Chief Drake regarding LPRs a couple weeks ago. I don't think we've sent that to the board yet, so can we send it when we get a chance? And we're still waiting on a response on that. Other than that, I think we should start with were you going to make any executive director remarks? No. Just a public hearing. Okay. Dr. Villier?
All right, thank you. So prior to public comment, we're planning on making a short presentation just to refresh on the key points of the report so that the public and viewers will understand the content of the report. So this report is an expedited report that was approved by the executive committee last month and was issued for public comment at the last board meeting. And it's in regards to soft empty hand control used to overcome resistance. So the MMPD manual, the revised manual, defines soft empty hand control as the use of physical strength and skill in defensive tactics to control arrestees who are reluctant to be taken into custody and offer some degree of physical resistance. Such techniques are not impact-oriented and include pain compliance, pressure points, controlled takedowns, joint manipulation, or simply grabbing a subject. Touching or escort holds may be appropriate for use against levels of passive resistance. Use of force is not required to be reported, or use of force reported is not required when soft empty hand control is the highest force used in an incident and there's no injury and no allegation of injury. There were recommendations by both the Community Oversight Board and the Mayor's Policing Policy Commission in October and November of 2020 to change this reporting policy. And as a bit of context, the police department uses a force continuum that outlines the levels of force in the department, and soft empty hand control is the step above giving verbal directions, and it's the transition point from verbal advice or persuasion or warnings to physical contact with an individual. And so when this is used in order to overcome resistance and uses those techniques that were in the definition, this report recommends that that would be a reportable use of force and provides a reporting mechanism. In the second recommendation, that would be a short form of the use of force report that is currently used by the department. As part of this report, we did analyze how often soft empty hand control is used by other departments, and we found that in analysis of 4 departments that do report soft empty hand control, found that between 1 in 6 to as high as 1 in 3 use of force incidents include uses of force that would not be reportable for MNPD. And we also found that reporting these is the norm and is becoming the norm very quickly. So we found that 51% of the 50 largest police departments that had publicly available data, which was 47 police departments that had publicly available data, or publicly available policies, pardon me, they have a reporting standard that's more comprehensive than MNPD. We also in the report make the case that Reporting should be required for a number of reasons. So first, accountability, tracking low-level force, such as these incidents in response to resistance, is an important management tool that can be used for early intervention, that can identify officers that might be at risk of more serious force or having other issues around wellness or substance use or other concerns that might be going on that management would like to be aware of, and help officers in their careers. For transparency, it would give a more accurate picture of the types of force that community members experience, as well as the resistance that police officers encounter. So it would give us a more comprehensive understanding of both sides of the equation. And evidence. This would help evaluate whether reforms and training is reducing the amount of force used. So for instance, if we want to know whether the verbal defense and influence trainings are, if there's a change in those trainings, if that has an impact, understanding the next level of force, which is soft empty hand control, that's where a verbal defense training and de-escalation trainings might make some of the most difference. And so understanding this full continuum will help us understand and evaluate whether the trainings and de-escalation is effective. And lastly, for risk mitigation. So this may reduce officer and city liability in cases where there might be a complaint against an officer of excessive force, but there's no force report. There may be some liability for the city or for the officer that could be mitigated by documenting that the department is aware of that force, evaluated that force, and that the supervisor signed off on it. And so that would could help the department as far as a risk management standpoint as well. So these recommendations, there's two recommendations that are proposed. The first is to MMPD that soft empty hand control techniques used to overcome resistance should be immediately reported to an officer supervisor and require a written report that's tracked by MMPD. Tracking of all soft empty hand control techniques used to overcome resistance should begin by January 1st, 2022. The second proposed recommendation is that officers using soft empty hand control techniques to overcome resistance without an allegation of injury should be required to complete a Form 108S, a form that would be created by MMPD to collect information about soft empty hand control when the force does not rise to the current Form 108 reporting level. And in the report, we detail recommended fields that should be included. It's based off of a similar form, the 108F form, which is also a short form for reporting the firearm displays. And we discuss in the report strategies that could be used to implement this. And the final proposed recommendation is to the Metropolitan Council, which is to amend Section 2.44.115, which is the reporting requirements for the police department to Metro Council, to require quarterly and annual use of force reports to be posted on the MMPD website, sent to Metro Council, and sent to the executive director of the COB. That includes the number of use of force incidents where soft empty hand control is the highest force used and there's no allegation of injury. And we included a sample ordinance in the report. Just as a clarification of process, the board voted to release this draft for public comment. Since it's an expedited report, the second two parts of this can happen at the same time. So the second step is a public hearing where the policy advisory report is the only agenda item. And then the COB may evaluate and vote whether to issue the revised report. In the standard process, these are separate meetings. When it's an expedited report, these can happen at the same meeting if the board chooses to. The board also has discretion to make decisions about whether to issue the report at a later time, especially if there could be any modifications to the report that are needed that are discussed during public comment. And finally, as the board approval process, the board can consider the report and recommendations together or separately. And the board can consider recommendations individually and choose which to approve. So the board can select which recommendations they would like to consider. Those can be done in small groups or all together. It's really up to the board on which aspects of the recommendations to approve. There can also be modifications, and that would just be done through a motion. When the report is issued, the proposed recommendations become COB recommendations and reflect the position of the board. So those would then, the staff would then advocate for those as the positions of the board. So are there any questions about the process that the board has before we go into public comment? Do we have a list for public comment?
Do you want me to read them?
Yeah, if you would like to call folks up. And we also have emails
Oh, do
that
we have
we're able to
people
read. If there are
here?
people in person, we can go with folks in person first. If there's folks here to make public comment.
There's just one name on here.
So we can open it up if there's. Oh, okay.
I don't have the list in front of me, so I don't know who's signed up.
Right. Jane, if you, yeah, you can go ahead.
Yeah, she can go ahead. Thanks.
That button, the red button. Good evening. I'm the Reverend Jane Borum. I'm with Christ Church Cathedral, and I'm also the co-chair of the Criminal Justice Task Force for NOAA. And NOAA has often followed and monitored police behavior in Nashville over the years. As a matter of fact, we worked hard to get the COB approved by the voters, and we're pleased to be part of the ongoing active process of the COB as it moves along. We have been waiting for reports and policy changes like this one because we know that our police department, if not monitored closely, will not follow all of the proposed recommendations, even from the policing commission that the mayor had last summer. So this is really a good step, we think, in that direction. We aren't taking a particular position on specific reporting details. We'll leave that up to the COB to make, what works best for you all. But we do want there to be some reporting mechanism, both to council and to the COB. And we are pleased that this is happening. I can entertain any questions if you'd like. Is that sufficient for you to know where we're coming from NOAA?
Thank you, Reverend Borum.
Okay, thank you so much. I'll turn the button up.
Now we can move to the email comments that we received.
Yes, I'll read email comments. From Marshall Bright, an email says, "Dear COB, I'm writing to echo your concern about the lack of reporting around soft, empty hand control used by Metro Police. The fact that police do not have to report violent actions like joint manipulation, pain pressure points, and grabbing people is indeed troubling and serves only to allow our police more unchecked power and obscure their actions from the public. As a Nashville resident, I'm also concerned that MNPD is not taking the concerns of the public seriously by failing to respond to the COB's recommendations. I'm writing in support of the board's recommendation that MNPD record all instances of empty hand control. I am in full support of the Oversight Board requesting and demanding the transparency that MNPD has refused to provide. Please register my support for the proposal." From Melissa Cherry, "Dear Oversight Board, I'm writing in support of your recommendation that MMPD begin reporting all instances of soft, empty hand control. MMPD has a record of obfuscating the data that they present to the public, and this seems like the most recent example. Reporting use of force statistics without including instances of force simply because there was no weapon involved and placing the obligation on the civilian to report this contact is disingenuous at best. I'm in full support of the Oversight Board requesting and demanding for the community the transparency that MMPD has refused to provide willingly. Please register my support for the proposal. From Kate Mason, reporting all use of physical force, including soft, empty hand control, is necessary for police transparency and accountability. It would allow for an officer's superiors to recognize early and often if an officer requires additional training in de-escalation techniques and/or is simply abusing their power. The police department should welcome thorough reporting to ensure community safety and prevent potential misconduct. Just as instances of physical force against police officers are reported, so should instances of physical force by police officers. From Jess Quasi. Hi, this is Jess Quasi, a resident of Nashville, Tennessee. All physical contact occurring between law enforcement and community residents must be reported from here on out. Of course, law enforcement reports anytime a community resident crosses the line of physical contact with an officer. So it is only fair that the reverse also be true. Yes, officer use of soft, empty hand control tactics need to be documented and then shared with the COB on a quarterly basis. In 2018, the Davidson County voters approved the formation and mission of the COB. The recommendations by the COB are thoughtful and reasonable. Thanks for listening, and may everyone be well. From Chase Moore, leave MNPD alone. These fine folks in blue don't need a bunch of do-nothing bureaucrats waving their fingers in their faces. Crime in this city is out of control due to Democrat policies, and everyone knows it. The Community Oversight Committee needs to be dissolved, as it serves to only worsen the situation in Nashville. If anything, this city needs more policing, self-policing within communities and self-policing within homes. That harsh reality falls on the deaf ears and eyes of those seeking political clout or office who compromise the Community Oversight Board and numerous other elected offices within Metro. Making Nashville a safer place begins and ends in the home, and you know it. Don't tell yourself otherwise. From Bob Scales. And as a note, Bob Scales is a former King County Deputy Prosecutor and Special Assistant United States Attorney for the Western District of Washington, and worked and represented the Seattle Police Department during the 2012 DOJ Patterns and Practice investigation and served as the compliance coordinator under the federal consent decree. Dear COB board members, I read your recent report recommending that Nashville Police Department begin collecting data on the use of force incidents that only involve soft, empty hand control techniques. We currently work with more than 90 law enforcement agencies in 8 states to collect and analyze use of force data. All of the agencies we work with include soft, empty hand control techniques as reportable use of force. This data is critical to understand how and why officers are using force and to evaluate policies and training programs. If you'd like additional information or would like to see online demonstration of our police force analysis system, please feel free to contact me. And Bob Scales is also the CEO of Police Strategies, which is a company that provides use of force dashboards to police departments. From Shayna Solomon, Dear Community Oversight Board, I would like to express that I share your concern about the lack of reporting of so-called soft, empty hand control used by the Metro Police. The fact that police are not required to report as use of force a wide range of physically violent actions, including joint manipulation, pain pressure points, and grabbing people, seems ludicrous. This serves only to hide the facts from the public. It allows the police to report lower use of force numbers because they fail to include actions that any reasonable person would see as force. As a resident of Nashville, I'm further concerned that it seems that Metro Nashville Police Department is not taking these concerns of the public seriously by failing to properly respond to the recommendations of the board. This change in policy is critical for everyone's public safety. Best regards, Shayna Solomon.
Thank you, Dr. Villier, for reading those. Now, the next step for us, do we need to suspend the rules again to approve the policies, or can we just vote if the board is so inclined to approve the policies?
I believe, and so one of the lawyer members or our legal counsel could correct me, but I believe since the rules were suspended in order to put this on the agenda for this meeting, that should be sufficient. But I would defer to someone with more expertise on that.
I see our attorney nodding. Mr. Goddard?
I'm going to take a different position on that. I called Jill if whether we're going to be on the agenda today and was told it was not on the agenda to vote. Now, that doesn't absolutely answer the question. My understanding of the Open Meetings Act is if you have a special called meeting, you can only do what's on the agenda. And we don't have a vote for this on the agenda. So I think it would be safer not to vote at this meeting.
Mr. Yoon?
Yes, I'm sorry, I was nodding my head without realizing that we did take it off the agenda. So now that it's off the agenda, it won't be up for a vote today.
And I made that decision based on the public comment because we thought that we might have comment that needed to change the policy because you never know what the public comment is going to be. And so I guess because we can't vote on it today, then we would vote on it at the next meeting in 2 weeks.
Okay. Then if that's the case, any questions by other board members about the process? If not, then we can move on to the PRRs. Okay, before we start those, I'll talk a little bit about what we're supposed to be doing here. These reports that we're going to review represent the totality of the investigation conducted, evidence collected, and conclusions reached by the staff. Our decision today should be limited to the evidence as presented within these reports. As a reminder, we are to be impartial in our review. We must be judicious and only consider the facts and evidence as presented here. Our rules state that we must presume that each report is correct as written. This presumption requires that all evidence was properly collected by our investigators and that the evidence was properly reviewed by the executive director. Then, based upon a preponderance of the evidence, made appropriate recommendations. Our role is to review the report as written and determine whether the report is adequate and whether the disciplinary measures proposed are sufficient and consistent with civil service rules. So, Director Fitchard.
Thank you. So on the agenda, I have how the order of the proposed resolution reports will be read. The first one, which is Mnco Complaint Cc 2020-010, is a case from the last meeting where the board rejected my recommendation to send it back for further or to be modified and come back with a different conclusion. And so on that report, I'm not going to go into the entire thing. It's on the screen up here, but it's related to an improper search and seizure, a vandalism, a discourtesy, and as well as, and that is, adherence to rules and policy against Officer 3, and that is what we will be talking about today. That was what the issue was in the last reading of the PRR. And so Officer 1 and 2, we found that those allegations were not sustained. And so I'll read the conclusion. The executive director concludes that after careful review of all supporting documents, MNCO investigative summary, and recorded interviews of the complainants and officers based on a preponderance of the evidence, the allegations for improper search and seizure, vandalism, and discourtesy against Officer 1, 2, and 3 are not sustained. The executive director does find that the allegation that Officer 3 violated MMPD policy 4.20.040, which is an adherence to policy and rules by way of not following the MMPD manual 6.20.080 vehicle holds. That is the issue in this report. And so my recommended action is that the executive director found that Officer 3 is in violation of MMPD Manual 6.20.080 vehicle holds, which is a violation of the 4.20.040 adherence to policy and rules. It's a Category D offense. The Officer 3 should have requested and completed an MMPD vehicle extension form, but did not. Typically, a first offense Category D offense is a 1 to 4 day suspension. After a review of Officer 3's disciplinary file, no other similar violations appear. The executive director also takes into account the fact that Officer 3 was filling in for the primary detective on this case, who was on an approved leave, and in making its recommended action of a written reprimand. Any questions about that?
Any questions for Director Fitchard? If not, I'll take a motion to approve the recommendations.
I make a motion to approve.
You do that on the mics.
I make a motion to approve.
Press the button. Oh,
It should turn red.
it should turn red. No, the top. It's all right. Mr. Hayes has made the motion to approve the PRR. Is there a second?
I'll second.
Thank you, Mr. Nguyen. Any focused discussion on that? Ms. McCree?
Director Fitchard, what weight did the fact that the officer number 3 was filling in for another detective have in your leaning to reduce to reduce the punishment to a written reprimand?
Well, he was filling in for a detective who was assigned to this case. Mm-hmm. And so that officer was on administrative leave. And so when you're filling in, like, he may not have known all the different particulars in what he was supposed to do regarding vehicle holds. And so that is why I made that decision, so that he would have this written reprimand instead of a suspension, because he was filling in and may not have been, is a part of his testimony, not really familiar with that case.
Perfect. And did he clearly state in his testimony that he was unaware of that policy?
He didn't say he wasn't aware of the policy.
Thank you.
Any other focused discussion on this? If not, all in favor of approving the recommendations, say aye.
Aye.
Any opposed? Well, the recommendations pass, and we can move on to the next PRR.
Perfect. All right, the next PRR is case number 2020-013. It's a little lengthy, so just be patient as I read through this. So 2020-103 is a complaint of an incident that occurred on December 6, 2019, but was reported to the MNCO on April 29, 2020 by email. Two complainants report sitting in a parked car when an MMPD patrol car rams them from behind. Multiple police officers are alleged to have approached with guns pointed at them, ordered them out of the car onto the ground, where they were handcuffed with their hands behind their backs. Complainants further allege that they were told inconsistent reasons about why they were initially stopped, not being provided names and badge numbers by any of the police officers except one, and believing they were racially profiled. Of the 10 allegations investigated against 3 officers involved, we sustained 1 against the lieutenant for deficient or inefficient performance of duties. MMPD Manual 4.20.050, Category F. In this investigation, it was discovered that the police were looking for an individual whose identification was known by the police with the help of undercover surveillance. The individual they were looking for was supposed to be in a silver or gray Nissan Rogue. Cell phone pings were also utilized in tracking this individual. A sergeant who was driving in a patrol vehicle relays to an off-site lieutenant that he observed a black male driving a black SUV. He also relays, "I'm not even sure this is the vehicle, so don't everyone follow me." Nonetheless, minutes later, the vehicle that is ultimately the complainant's car is authorized by the lieutenant for the sergeant and officer to initiate a vehicular block. This is also after the fact that the information is relayed to the police that the individual in the vehicle they are after is located at John Early Middle School, which is about a half mile away from where the complainants were on Buchanan Street. The officer identified in the report is the actual officer whose bumper makes contact with the complainant, and is who gives the complainant his card and his identifying information. The officer denies handcuffing or ordering anyone to the ground. He did not recall, when asked, if the second complainant was forced to kneel on the ground by him or other officers. The officer also denies anyone searched the car, but claims it was looked into with flashlights from the outside without opening doors. The sergeant states that he does not remember if anyone was handcuffed, and he did not see anyone placed on their knees. Both officer and sergeant did admit to displaying their guns, but deny saying, "If you move, I will shoot you." It is undisputed that there was no vehicle damage after an inspection at a body shop. There was no body camera or video from the helicopter per the responses to our requests, but there were several hours of radio and audio recordings that the investigator reviewed. As a result of the investigation, we concluded that the allegations of misconduct against officer and sergeant for discourtesy, improper search seizure, lack of professionalism, excessive use of force, and obligation to self-identify could not be sustained by preponderance of evidence. We did find that the lieutenant violated MMPD 4.20.050F, Category F, he's deficient or inefficient performance of duties, the category of which varies by the severity of the violation, in authorizing the vehicular block by the officer, particularly in light of the fact that the sergeant twice cautioned he was not sure the vehicle contained the suspect they were looking for, and they had independent information that the person they were looking for was elsewhere. The lieutenant's disciplinary action was in 2019 for parking in a no parking space, which is a Category F offense. He received a formal counseling. The recommended discipline here, based on the severity of the violation, is a Category E first offense, a 2-day suspension against the lieutenant.
Thank you, Director Fitchard. Any questions for this proposed resolution report? Mr. Campbell-Gooch.
So, quick question, and I just want to make sure I have my facts right. There's a silver Nissan at John Early, but a black Jeep is pulled over. If I got that correct, right? A black Jeep is pulled over on Buchanan.
Yes.
Okay, so I'm just spatially thinking. So, throughout this, where are all the breakdowns? Because this feels like a multi-tier breakdown.
So this case is a little, there's a lot going on in this case. At the time that this happened, there was multiple juveniles who had escaped from the juvenile detention center. Mm-hmm. And so you had multi-agencies who were involved in looking for those juveniles who had escaped. And so at the time, you had not only the MMPD, you also had agencies from, federal agencies involved in this too. So there's a lot of things happening at the same time. And so they, for some unknown reason, they stopped the black vehicle on Buchanan Street. And it's kind of difficult. They were actually looking for a silver or gray Nissan Rogue. And so there is some confusion about the black, because of course they're looking for juveniles and these are adults in that car. So there is some confusion about that. And I think that the reason why the lieutenant is held accountable is because he's privy of this information and still decides to block and jam the vehicle and pull those people out of the car.
And so if we, and just walk me through it. So if we have, what was the rank of the other officer? I know we have a lieutenant and then a sergeant. Do I have that
No,
right?
the lieutenant, you have the lieutenant who's not on the scene. You have a sergeant and an officer.
Gotcha. So
But
when,
of course, those are the only people, I'm sorry, the only officers that are, at that point, we even know who's involved, right? Because of course, there's probably 10 to 15 people out there, but we just don't know who it is. And it took us a while to determine, we only had that one card and who else was around.
so if I got this right, so the lieutenant okays the sergeant and officer's request to pull the Jeep over,
To do the block.
to do the block. But the sergeant and the officer do the block.
That's correct.
Okay. I just wanted to make sure that was clear, because you're right, it is a lot going on. So I just wanted to make sure I had the series of events right in my mind.
Thank you, Mr. Campbell-Gooch. Dr. Hildreth.
Thank you. I have a clarifying question that follows that from the facts, and I'm reading from page 5 of 7 of the report that was published on the website, where in item number 10 at the top of the page, it says that the sergeant also relayed prior to the vehicle block. I'm not even sure that this is the vehicle, so don't everybody follow me. So is that the officer who had and voiced misgivings, is that the officer who nevertheless participated in the block?
That's correct.
Thank you.
Thank you, Dr. Hildreth. Any other, Mr. Campbell-Gooch?
So, in this type of circumstance, is it safe to assume that the officers could have also just pulled the Jeep over without executing the block?
That's reasonable.
Okay,
Yes.
I'm just trying to figure out, I'm just trying to figure out if no one has attempted to pull the car over, why block it without
Right, they
doing
did a
anything
jam.
else? Right.
Correct.
Okay.
And this is the Juvenile Crime Task Force that's doing this.
Any other questions? Oh, Mr. Goddard.
Yes, thank you. If I understand right, Executive Director Fitchard, this is one of the policy provisions, violation of which can be A, B, C, D, whatever, depending on the nature of the violation.
That's
And-
correct.
And we've got it recommended at, get my letters right here, at E, which is the next to the lowest. With the, somehow between the sergeant and the lieutenant, what appears to be some actions taken solely or almost exclusively on the race of the suspects, is E appropriate, or is D a better? I'm going to ask that question differently. How do you determine E as opposed to, say, D?
Oh, why did I determine it was an E?
Right.
I determined that it was an E because at the time, he didn't have any other discipline in his record. And so I made that determination based on that. And based on his interview. So I thought that was appropriate. And if the board wants to make a change, we can do that too.
Ms. McCree.
If you don't mind me asking, what about his interview made you go with E?
Well, just because of how he felt that it was appropriate.
If there are no other questions, I'll take a motion. Mr. Campbell-Gooch.
I guess my question is for board members, and I'm looking at category D. And since it feels like there was an action that was taken because of the race of the suspects, but also in North Nashville, just in general, right there on Buchanan, there's always a swarm of police officers. I'm curious if D, and I'm curious on what other board members think. I'm curious if D would be justified in this situation. And the only reason I'm saying that is because, one, there's cell phone records that say the car that they're actually looking for is in another area. Two, 2, it's not the same vehicle, not even the same color, make, or model. And then 3, there's a jam instead of just simply attempting to pull over the suspect. You know what I'm saying? So I'm just thinking that if actually pushing this up to D is actually justified, so I'm curious on what other board members think.
Thank you, Mr. Campbell-Gooch. Any thoughts there? Mr. Nguyen?
This is for the director. When you interviewed the lieutenant about this, this was an active search for suspects who escaped from detention.
That's correct.
So it wasn't a rolling surveillance. It wasn't an operation that had been planned. This was a reaction to the escapees, right?
That's correct.
Okay. So did he say that this was the only armed encounter that they had during the search? Were there other moments where they stopped cars, pulled people out, did frisk and stops? Did any of that go on during, or did he report any of that?
Call that. You can say that. I don't recall every.
There was at least one other vehicle jam that was authorized that night against another vehicle and other suspects.
And what happened with that one, Daniel?
Well, they didn't find the person. That was also an incorrect jam, and but I don't remember any specifics about whether excessive force was alleged, and we didn't look into whether weapons were pulled, but it's, yeah.
And they didn't make a complaint to us, so we wouldn't know.
I'm sorry, say it again?
I said whoever got stopped never
Right.
made a complaint to us, so
Okay.
I wouldn't know exactly the entire encounter.
Okay. Well, I'm just trying to put it into some context.
Right.
Were they stopping people all around the area just to see if they were, the escapees or not? That would be my question. The other thing, too, I'd like to know is, when you talk to him about this, obviously he knows he's been scrutinized for this incident. And at some point, did he say, I didn't want to take a chance on it being them and not authorizing a stop?
I don't recall him saying that.
So he mentioned nothing about risk-benefit of calling off the officers and say, don't do this, don't pull them over. He didn't, that reasoning didn't come out in the interview where he said, I couldn't take a chance, and then bypassing it and possibly being the escapees?
I don't recall him saying that.
Okay. All right. Thank you.
You're welcome. And remember, there's multiple agencies. I don't remember every agency, but I would say you had different federal agencies involved, and they could have been stopping people. We wouldn't have any record of that. We don't even know if they were on the scene at this particular instance. And when you're dealing with the ATF, or you're dealing with the Secret Service and all these agencies that are here in Nashville helping with this process, they aren't reporting that information because we can't get that information. So
Well,
I don't know if another stop was done and it was a different agency doing it.
was this an incident command operation?
I don't know if it was a command. Was it a command operation?
In other words, was he the incident commander of the search,
Yes.
the lieutenant that you interviewed? So you're telling me that you've got multiple law enforcement agencies that are involved in a critical incident command situation with their escapees, and there's no command and control of all those other agencies in the middle of a search?
It seemed very chaotic, from what I understand. And I'm not the investigator. I didn't investigate it. And so some of your questions could have been and could be contained in the file in regards to that. But specifically, the information that we have is what we have before us.
But don't you think that if you interviewed this lieutenant
The
and asked him
lieutenant was
how this...
interviewed.
You did interview him?
I didn't interview him.
Oh, I'm sorry.
Right.
Sorry.
Yeah.
So who at COB interviewed him?
One of our investigators.
Okay. So in that interview, at any time did this lieutenant say, I was the incident commander of the escapee recovery search operation, and all other agencies that were in the area searching were reporting directly to me as part of the incident command process?
I don't recall him saying that. Let me see.
Mr. Nguyen, just as a reminder, we've had time to go to review this evidence, and what we're doing here is analyzing what is solely in the PRR.
I know that, but my concern is this: if in the middle of a disciplinary review of actions of the officers, and it's discovered that they're doing something that needs to be addressed, as important as having command and control over multiple law enforcement agencies in the jurisdiction of Nashville, Davidson County, searching for suspects, and it's chaotic, is what I just heard, then that needs to be, I think, addressed. I mean, it just seems that we don't know how many other people they stopped that night. You're telling me there's only one other recorded. I'm not saying we should, stop officers from searching for escapees. That's not what I'm saying, but there's a process here with something this important and this dangerous.
I will share this with you, and I think that we're right. I don't want to get into the specifics of the investigation because, you've had the opportunity to come into the office and read that file, and I don't want to, get deeper into it than here, but I think that your questions are valid. One of the things that the captain stated is, in this room, I'm in it with the command. I cannot remember whose command it was that night. I would have had resources there from gangs, the marshals, task force, BCC. We would have had monitors pulled up with the maps and any other intel we were working with. And he says we were basically on the whatever channel, which was the primary channel for the Juvenile Crimes Task Force, but we also had 2 TAC channels assigned to the Juvenile Crimes Task Force as well, which would not have been recorded. And the other car that was stopped was a white Nissan Altima. Thank you.
Thank you.
You're welcome.
Dr. Hildreth and Mr. Kemelgooch.
Thank you. I just have a process clarification question and one. I'm very interested in the line of questioning from Member Nguyen. I'm learning about distinctions and almost how to come up with a checklist in my own mind as a member as I'm listening critically to the report. One of the things that I'm conscious of as I was prepping for today's special meeting is that we find ourselves here because we are clearing out the backlog. And one of the reasons we're clearing out the backlog, as we well know, is we never would have been able to do this in real time, because if we look at time and look at who leadership was at the time, that wasn't going to happen. So assuming that some of this disjointedness is not going to happen in the future, I'm still wondering if it would be helpful going forward, and I really appreciate these public reports, would it be appropriate or not to indicate when the MNCO interview happened? We have beautiful timeline here of dates of occurrences, but I also was wondering, with perhaps less of a critical faculty, but I still wanted to know, when did the event happen and when did the interview happen versus our deliberation now, and wondering if that just factors in. So I'm not quite sure if that's a process recommendation or just a wondering out loud, but thank you for allowing me to say it out loud and think this through together. It's very helpful.
Yeah, I think that if you look at this investigative report, which is very lengthy, it's over 20 pages, it's very telling. It gives you a clear picture of the incident and what was happening. And the lieutenant was interviewed on December the 23rd, 2020 at 9 a.m. Let's see.
I guess follow up when you said if you look at this report, that report that you just lifted up, is that available on the website? Is that the public?
No, this contains confidential
That's what I wanted to
information.
clarify.
He was interviewed twice, by the way. He was interviewed December the 7th, and he was re-interviewed on December the 23rd for clarifying questions.
Thank you.
But this is available to you as board members.
Right. So that's one of the things that I wanted to say out loud, because one of our practices up here is we talk to each other, but we also talk to the public, both those who are in the room and those who are watching and trying to understand how their work to stand up this board happens. And so I will say that I am reading and following from information that was available to each and every one of us on the website, and I would like to give kudos to whoever made that possible. But to also know, just from a process standpoint, that properly There are some things that are available to all of us, and there's some things that are only available in the MCO office. We board members may make an appointment to go see it, but we don't, so that's where some of this slippage and understanding happens. Thank you so much.
You're welcome.
One second. Mr. Yoon?
I just wanted to name that, I guess, April is when we received the complaint of 2020. We interviewed the officer December of 2020, and all of the board members here are aware of it. For the public, there was a significant thing that happened with a new memorandum of understanding with the new police chief that I think prompted that interview versus why we weren't able to for about 6 or 7 months.
Mm-hmm.
Thank you, Mr. Yoon. Mr. Kamalguch?
Yeah, I just wanted to talk about like the facts that we have in the report, which are we have 2 people who have issued a complaint because of an intense and fearful situation where they were asked to get out of a car and they alleged at gunpoint. And then we also have a multi-tier failure happening inside the command structure where there's been approval for a force happening on a car that doesn't even match the make or model and is not where they are actually pinging from the cell phone towers either. So with that being said, like those are the facts that we have. And I'm afraid that if we broaden out to talk about a whole lot of other stuff, we lose out on the experience of these 2 community members who, in that midst and in that temperature that Dan Yoon just talked about, are pretty actually very afraid for what's going on. So I just wanted to hold that and also just say again, I'm curious on how board members feel about going to a category D because we do see a multi-tier failure. And fortunately, the most tragic thing did not happen. But being a person who experienced these things before, the lasting effects can last a very long time. So I just wanted to hold space for that and mention that again.
Thank you, Mr. Kamalguch. Before I move to you, Ms. McCree, I'm going to remind the board that we have 4 options: to accept as submitted, accept but with edits, reject and request a revision that reaches a different conclusion, or return for further investigation and analysis. Ms. McCree.
Thank you, Chair. In response to Mr. Kamalguch, I wholeheartedly agree that it is appropriate to move up to a Category D and still keep the 2-day suspension as a first-time offense. Let's see here. That would increase the retention period to 36 months outside of the 24 months in a Category E, and I agree with you in that aspect.
You can make a motion to that respect, Mr. Kamalguch or Ms. McCree.
Yeah, motion.
There's no motion on the floor.
Chair, can you please read off the 4 options again, please?
Sure. We have the 4 options are accept as submitted, accept but with edits, reject and request a revision that reaches a different conclusion, return for further investigation and or analysis.
So would this be a situation where we need to accept with edits or reject to a different conclusion?
I think this is a situation where we have to reject with a different conclusion. Is that correct, Mr. Goddard?
I seem to be disagreeing a lot tonight. I'm sorry. I think we can accept with the revision that member McCray just talked about. I believe I believe we've done that before in one case, and I think that would be the appropriate.
It'd be accept but modify.
Correct.
Accept but with edits. Okay, so we still don't have a motion on the floor, though.
So I would like to make a motion that we accept, this PRR, but with an edit to move the discipline to Category D, which changes the retention rate to 36 months, but leaves the suspension at 2 days.
Second.
Thank you, Mr. Kamalguch. Thank you, Dr. Hildreth. Mr. Goddard, is your things Ms. McCree? No. Any focused discussion on the motion? If not, all in favor of the motion, say aye. Any opposed? Any abstentions? The motion passes. We can move on to the next case.
All right. The next case is Mnco Cc 2020-018. It's a complaint we received on May 19th, 2020 regarding an incident that occurred on May 9th, 2020. The complainant is a former MMPD police officer who was a witness to a traffic accident involving the officer referred to in the complaint and another driver. It is undisputed that the officer was at fault in the accident. What was in dispute was the officer's interactions and behavior following the traffic crash. No one is alleged to have been hurt significantly physically as a result of the traffic crash, and no one went to the hospital following. In response to the accident, the driver of the other vehicle states that he asked officer, "Hey, are you okay?" In response, the officer is alleged to have responded, "What the hell is your problem?" Complainant who observed the accident claims that the officer was cursing and yelling at the driver of the other vehicle, so he stops and tells the officer that he cannot speak to the driver that way and that he had seen the accident. Complainant and driver both alleged that officer cursed and yelled at the complainant at this point. It is undisputed that a supervisor was called and appeared, and that the officer was not cursing and was not yelling upon the supervisor arriving. The officer's statements to investigators was that he was turning into an apartment complex in order to turn around and did not need to use a traffic signal because he did not see any oncoming traffic. In the body cam reviewed immediately after the accident, however, the officer alleged that he probably had his turn signal on because he is pretty good about that, and that he was going to turn his blue lights on after the turnaround. The officer also claimed that he ordered the complainant to the side because the complainant was blocking the flow of traffic. I concluded, based on the preponderance of the evidence, that the allegations that the officer violated courtesy, responsibility, profanity, and self-control are sustained. Courtesy and profanity are Category F violations. Responsibility and self-control are Category D offenses. It is noted in the PRR that the OPA also investigated this matter and sustained one violation of self-control and disciplined the officer with a 1-day suspension. I am recommending a cumulative action of 4-day suspension for all violations. And I will say that there was profanity used more than once here, even though I just in that summary said the one thing. He also, in response to the complainant, said, "Well, since you are a goddamn witness, get your ass over here and park." And my recommendation is that for courtesy, it's sustained. The recommendation is an oral reprimand. Responsibility, sustained. Recommendation, 1-day suspension. Profanity, sustained. Recommendation, an oral reprimand. And self-control, sustained. Recommendation, a 3-day suspension. So the recommendation is a total of a 4-day suspension.
Thank you, Director Fitchard. Any questions from the board about this report? Mr. Hayes.
Which category is this? Does this fall in the category?
So this is where the officer is in violation of MMPD Manual Section 4.204.40. The G, courtesy is a G. And I'm sorry. I'm not reading that correctly. Hold on, let me go back. Okay, courtesy is a Category F. And that's my recommendation was an oral reprimand. Responsibility is a Category D. And my recommendation is a 1-day suspension. Profanity is a Category F. And my recommendation is an oral reprimand. And self-control is generally a Category D, but may vary by the severity of the violation. And my recommendation is a 3-day suspension. I will say, it should be noted that officer received a written reprimand for violation of the care of government property, the vehicle, and then a 1-day suspension for violation of self-control related to this incident and his actions, and that was done through the Office of Professional Accountability.
Judge Brown.
Oh, sorry, thank you. Too much technology. One question I had, the officer denied using any profanity. Does that get you over into a violation of truthfulness?
We thought about that. And, you know, I think that the reason why we didn't deal with the truthfulness is based on a preponderance of the evidence. That part wasn't recorded. There was a video of the interaction between, or some of the interaction between the officer and the complainants and the witness, but the recording started right after the alleged profanity started.
Okay, so we don't have any recording of profanity, just the testimony of the two witnesses?
That's correct.
Okay, thank you.
Ms. McCree?
Just for clarification purposes, so out of the two Category D offenses that we have, the responsibility and self-control, which combined could have up to a total of 8-day suspension for both of the two, we are dealing with the 4 in total.
That's correct.
Okay, perfect.
Mr. Campbell-Gooch?
Yeah, and on that pathway, so if just so I can make sure I understand it correctly, the recommendation is that for additional days or for including the one that the officer has already experienced?
I did not take into consideration OPA's suspension or these are based on our investigation, not OPA. So if in fact the board decides for the self-control and you sustain that 3-day suspension for that particular category, this officer would have received a 4-day suspension regarding self-control in totality.
Mr. Nguyen?
I don't disagree with the director's assessment of this. It just seems to me, though, and this is something you can take as a suggestion, or maybe we can do it, maybe we can't. And that may be something the doctor and some of the staff might be to address to us as a board, is the impact of trauma on anybody when it comes to incidents like pursuits, shootings, traffic accidents. It doesn't matter whether you're a police officer or not, you're going to be traumatically impacted, which means there's going to be things happen inside your brain that you can't control. And I'm not excusing profanity of these officers. It's not proper, it's not professional. But I think when we judge these officers for what they do and what they say after a traumatic event, we should at least understand what's happening to them neurobiologically. There are things that happen to you, like rape victims and domestic violence victims. We should understand that before we make judgment. Because we're going to see this, I think, again and again and again, where officers will spontaneously say something or do something, and it's wrong, and they shouldn't do it. They should control themselves. That's why the rules are there for self-control. But we should at least consider the human aspect of what happens to people when they're traumatized. I wanted to mention that in this, but I agree with your assessment in the case.
Right, and I think that on this, thank you for that. In the self-control, I think that the issue, and because profanity is on this grid, as you notice, a category F, it's a low, impact type of category, right? But I think the bigger issue here is the self-control, right? If you're talking to an ex-Metro police officer and he's saying, and we were able to hear, he's like, you can't talk to me like that. There is video, we couldn't hear some of it, and then when it pops on, you have an ex-officer who is the complainant saying, you're not going to talk to me like that. I know you shouldn't be carrying on like that. And I did take into consideration that the officer was involved in an accident at the time. And so I think that this is a fair recommendation, but the board can make whatever determination you desire.
Thank you, Mr. Nguyen. Thank you, Director Fitcher. Mr. Campbell-Gooch.
Yeah, I think what Board Member Wynn said makes a lot of sense, as long as that's a two-way street, because I just feel as if, I don't like to be cursed at, so I just feel as though if an officer who is entitled to use deadly force if necessary is cursing at me, I think I should be able to curse back. If we're going to have both of those incidents, but I know it's not going to play out in my benefit. So I just want to hold and say that as community members file complaints and go out of their way to do so, that we hold that there is trauma also happening to community members who have an extra responsibility to be respectful and poised in a moment where their brain might be telling them to defend themselves.
Thank you, Mr. Campbell-Gooch. Any other discussion on this proposed resolution report? Mr. Brown?
I move we approve it. It would have been interesting to know if he went to the ER or something, but apparently not.
He did not.
I move to, we approve.
Thank you, Mr. Hayes. Any focused discussion on the motion to approve? If not, all in favor of approving the proposed resolution report, say aye.
Aye.
Any opposed? Thank you. The recommendation passes, and now we can move on to the next proposed resolution report.
All right, the next one is Mnco Complaint Cc 2020-028. In this case, the complainant spoke to an Mnco investigator on July 6, 2020 about an incident that occurred on April 6, 2019. The allegation from the complainant are that a Metro officer, referred to as officer in the report, was dishonest by way of inaccuracies in the report, and number two, made an improper search and seizure of his handgun. We interviewed the complainant, and examples of the inaccuracies, dishonesties alleged are the officer used the pronoun she in one line of one page of about 14 pages in total. We noted that the officer also used a correct pronoun he and him a couple dozen times, and that the driver of the other vehicle was a woman. We did not sustain the allegation that the officer was knowingly or intentionally making a materially false statement. Materially meaning it could have affected the course of the outcome of the investigation. As to the improper search and seizure, the complainant alleged that the officer did not have justification. Our investigation concluded that the handgun was seized after the officer had reasonable suspicion that the complainant was both driving under the influence and in possession of a handgun while under the influence, which even if he had a valid carry permit, it still would have been a violation of the law. On February 27, 2020, the complainant pled no contendere to both criminal charges, which means he accepted the convictions and punishments of the crimes, but he did not admit the factual basis was true. And the complainant filed this complaint about 4 months later. And so the allegation of dishonesty is not sustained, and the allegation of improper search and seizure is unfounded.
Thank you, Director Pritchard. Any questions on this proposed resolution report? Mr. Brown.
I just had one question. I noticed the incident occurred on April 6th of 2019, but the complaint wasn't until 15 months later on July 6th of 20. Was there any particular reason that why the complainant waited so long? Because of the criminal case, or?
Yeah, I'm not really sure. I believe that it had something to do with his attorney may have told him to hold off. I mean, that has happened we've had several cases like that now, where they would prefer to go through their process before filing a complaint with us.
Okay. Well, if there's no further discussion, I'd recommend approval. A motion to approve.
Thank you, Mr. Brown. There's a motion to approve. Is there a second?
I second.
Thank you, Mr. Abdullah. Any focused discussion on this proposed resolution report? If there is none, all in favor of approving the recommendation, say aye. Any opposed? This recommendation passes, and we can move on to the next report.
All right. We are on Mnco complaint number 2020, CC 2020-030. The complainant spoke to an MNC investigator about an incident that occurred on June 30, 2019. The allegations from the complainant are that a Metro officer referred to as Sergeant in the report made false statements, did not appear in court, was untruthful, failed to buckle her in during transport to the jail, and put her handcuffs on upside down or incorrectly. From our investigation, we concluded that the failure to buckle, making false statements, and putting handcuffs on could be sustained as policy violations, could not be sustained as policy violations. The non-appearance in court, however, we did sustain. The complainant alleged that the sergeant missed multiple court appearances. We counted 5 times that sergeant was subpoenaed to court. Sergeant, during his interview, admitted to missing court on 10/6/2020 for a lot of things going on and not remembering if he missed any of the previous court dates. After going through the court file, we saw that he had been served with 5 subpoenas to appear in court, and he did not receive a subpoena cancellation or permission to not appear by the District Attorney General on 10/6. Therefore, we sustained the allegation by preponderance of evidence that he did, in fact, violate policy. That is the overall substance of the report. One issue with this case that I do want to highlight for the board is actually something that occurred after the investigation was completed and the report was published and sent to you. The attorney for the sergeant in this case sent an email after he received the PRR notifications, and he stated that the officer missed court dates because of many factors. I'll bring those up in a minute. As you know, we've created certain safeguards to protect the rights of the police department employees we interview to ensure they are afforded ample due process at every turn. In this case, for instance, as part of the investigative process on 10/7/20, the MNCO investigator sent a letter to the sergeant with a description of the complaint, who made it, what it was alleged, and generally saying this letter is to serve notice that a complaint against you had been filed with Metro Nashville Community Oversight. 3 weeks after that, on 10/21, another letter was sent out reiterating the same things to schedule an interview. 8 days after that, on 10/29, the interview was held, and at the very beginning of the interview, we read a statement that is similar to Garrity rights to the officer. And I'll just highlight a few of those. It says you have the right to be informed of the allegations. You'll be asked questions specifically directed and narrowly related to the performance of your official duties or fitness for office. The statements made during any interviews may be used as evidence of misconduct or as a basis for seeking disciplinary action against you. And there's others. It says if you refuse to answer questions relating to the performance of your official duties or knowingly provide false or misleading information, you will be subject to discipline from MNPD, which may include dismissal. In this instance, and in most instances, the sergeant had an attorney present throughout the interview, and he has maintained contact with us. In this instance, and in most instances, the sergeant read a statement during the interview where the sergeant stated, "I'm here today to give a statement regarding the events of June 30, 2019 only. I understand I'm being compelled to give a statement. I intend to give you truthful account of my perceptions of the incident of the best of my recollection. Prior to, during, or after the interview, if any video, audio, or documents made by any person related to the incident become available, I request to be permitted to review it and reserve the right to amend my statement." That is a statement that all officers read to us during this process. In this case, the sergeant had nearly 365 days to supplement, add, modify, retract anything he said to us before we published our findings. I say all this to say that you, the board, and we, the staff, have done everything possible in our SOPs, rules, and bylaws to create a process where due process to defend, explain, and refresh their memory is amply afforded to the MNPD at every turn and every step along the way. And in the event that material evidence is uncovered or the sergeant wishes, he can appeal the decision of the board. There are multiple checks and balances in place in this process. So what I would urge the board to strongly consider is that when we consider information after a report is published, it affects the following. Not only does it recommit our investigators and staff from other duties to reinvestigate, it also deviates from a standard of review we choose, a legal presumption of correctness of the report when we take in extra information after a report is submitted. It delays the timeline. It also affects the fairness of the process. If we were to modify our report findings, exhibits, and everything during the time between it is published online and presented to the board, we would have to give notice to everyone involved. We have to share that information to any other people involved, give them an opportunity to change their side, and send that to the other side as well. In the event that we change the report in any significant way, either party can still appeal it, and we would have to push the deadline even further back. At some point, we have to stick to the process that we choose out of fairness to everyone. All that being said, with the information we did receive from the attorney after the report was published, I decided to investigate it to determine if there was anything that we missed. And would it have affected the conclusion and recommendations? And in this case, I believe while the findings and conclusions are the same, the disciplinary recommendation I made was based on 4 missed court appearances. So I would ask that you accept the report and potentially modify the disciplinary action you take. And the reason for that is when we begin to look at the cases that the gentleman had, and I'm not going to get into that, but he was subpoenaed for, actually had 6 court dates, and he was subpoenaed for 5 of those court dates. Therefore, I categorize this as a 1 level up to a Category D offense, which can lead to a 1 to 4 day suspension for a first offense, which this is. I recommend a 1 day per missed court date for 4 total days. And although the information provided by the attorney after the investigation was over claims that 2 of the 6 total missed court appearances were cancellations due to COVID. 1, he was out on FMLA. 1, he did attend and was released by the District Attorney General's representative. And 1, he did not provide an explanation for not appearing. He did say something like his attorney said he needed time to sleep because of working multiple shifts. But what I would say to the board is this, that it's just like if you're in a court of law and you have all this time to present everything that you have. And then once you're at the jury, the jury's making their decision, and then somebody busts through the door and says, oh, wait, while they're in the deliberating, I need to add this information in because I did not do it. There were 365 days that this officer, when he sat there, when questions were being asked of him, and he wasn't really fully cooperating. He knew the days that he missed. He had an opportunity to tell us that time, and he did not. And so I think that my recommendation can be modified. But I did want to make certain that this process, because I don't think that the officer was being cooperative during this process. And then, of course, his attorney sends us dates and saying, hey, have you considered that he missed these dates for this reason? It's not fair to the complainant, and it's not fair to this process.
Thank you, Director Fitchard. Dr. Hildreth.
Thank you. Move to accept and send to MPD Police Chief the report as it was originally submitted in timely fashion. Thank you.
Thank you, Dr. Hildreth. Is there a second?
A second.
Thank you, Mr. Campbell-Gooch. Any focused discussion on this report? If there is none, all in favor of approving the recommendation, say aye.
Aye.
Any opposed? The recommendation passes.
All right, this is our last case, and this case is case number Mnco Case Cc 2020-005. This was a director-initiated audit of an OPA investigation. The OPA, audit was completed by Assistant Director Christopher Clausey. We audited the OPA's investigation of 5 officers involved in the search warrant application surveillance and breaking in of a residence involving a woman and 2 minor children while they were sleeping on August 2020 at around 6 a.m. in the morning. It was discovered that the officers had failed to adequately investigate the information leading to the wrong home that was broken into, and the woman who resided there was not allowed to dress before they broke down the door. It received substantial media attention. The chief of police initially decommissioned 3 officers and changed policy surrounding the approval of search warrants. One major deficiency was the police relying on an MDHA resident list that hadn't been updated since November 2018. We did not find any deficiencies with the OPA's conclusion in regard to 4 out of 5 officers. Officer 1, no wrongdoing was sustained. He was not involved in the drafting, review, or approval of the search warrant leading to the complainant's home. Officer 2 was the drafter of the search warrant. He failed to surveil the location where he would have discovered that the person they were looking for had moved out 4 months prior. He is the one who relied on the outdated MDHA list to confirm the presence of the person they were looking for. Officer 2 sustained violations were MMPD Manual 4.20050, F, deficient or inefficient performance of duties, and Manual 4.20040, the adherence to policies and rules, which was a Category D, by way of violating the search warrant application by failing to actually surveil the home or otherwise confirm that the person who lived in that residence actually lived there. A Category D offense is typically disciplined with 1 to 4 day suspension. Officer 2's previous disciplinary actions were a written reprimand in 2018 for taser deployment during a test fire. 2, a 1 day suspension from vacation for failure to appear in court in 2018. And 3, a written reprimand in 2020 for losing a holster. The department's disciplinary action for these offenses were a 20-day suspension without pay. As it relates to the sergeant, he not only failed to adequately supervise Officer 2, he also violated policy by forcibly breaching the door while the complainant is heard verbally responding to the police, asking for more time to get dressed because she was naked. Specifically, Sergeant was found to have violated the same 2 policies as Officer 2. MMPD Manual 4.2050, which is deficient or inefficient performance of duties, and MMPD 4.20040, adherence to policy and rules by way of violating MMPD Manual, the execution of a search warrant. Again, this category of the first violation varies according to the severity of the offense. In this instance, the sergeant was, his previous disciplinary history was a 4-day suspension without pay in 2004 for violating a pursuit policy, a 1-day suspension from vacation in 2008 for failure to appear in court, and then a 1-day suspension from vacation and an oral reprimand in 2014 for violation of a pursuit policy. And he was, in this instance, the sergeant was disciplined with 30-day suspension without pay and a demotion if he received another violation in the next 5 years. The third officer was sustained violations that we found no deficiencies with is the lieutenant. He was found to have violated the same policy, which is 4.20050, deficient or inefficient performance of duties, and in this instance, it was determined that he never conducted a thorough review of Officer 2's search warrant before it was executed, even though Officer 2 had sent him multiple emails. The lieutenant reported thinking that the other sergeants had done a thorough review, but admitted that he was the one responsible for doing so. He had no relevant disciplinary actions. He was demoted to sergeant and was suspended for 10 days without pay. Finally, the commander was investigated and a violation was sustained for MMPD, deficient or inefficient performance of duties. He had no disciplinary history. He was sanctioned with a formal counseling. And this is where our report and audit find that OPA's conclusions are deficient. The commander was only found to have violated 1 section of the policy, but the assistant director, Chris Clausey, identified 3 subparts that appear to have been violated. While OPA sustained subsection 6, faulty decision-making or poor judgment, the assistant director identified subsection 1 and 4, which read, demonstrated inefficiency, negligence, or incompetence in the performance of duties, and failure to supervise and or carry out the duties and or the responsibilities of a supervisor. During the investigation, it was determined that Commander had been made aware that Officer 2 was having extreme difficulty performing his duties prior to this incident on 2 separate occasions. In his previous assignment, the commander received negative feedback from 2 detectives and the unit supervisor about Officer 2's deficient work product and poor attitude. In fact, it was Sergeant who participated in this botched raid that approached the commander and advised the commander that Officer 2 had displayed several deficiencies in multiple areas, including most notably surveillance. The sergeant asked Commander to remove Officer 2 from his assignment. After speaking to Sergeant at length about Officer 2's poor performance, the commander did not remove him as requested and told Sergeant that until Officer 2 has been properly trained and deficiencies documented, the commander would not remove Officer 2 from his assignment. Following this conversation over the next several weeks, the commander was advised by 2 detectives that Officer 2 had continued to perform at a low level, and both filled out supplements documenting their concerns. The commander had been made personally aware of Officer 2's poor performance and extreme difficulty in performing the duties associated with being a member of his detail prior to deciding to move to Officer 2 in an assignment that would have led to this botch raid. And additionally, the commander acknowledges that he did not do the vetting process and ignored all the information he had when deciding to place Officer 2 in the 2-man unit that reported directly to the lieutenant and failed to provide or ensure that Officer 2 would get additional training. And for the above stated reasons, this proposed resolution report includes a recommendation that the commander receive a Category E offense and a 2-day suspension.
Thank you, Director Fitchard. Mr. Nguyen.
Yeah, this is a complex complaint. I understand that. At any time, did anyone in the command staff say why the commander shouldn't be punished? That's one question. Held accountable. Was there any reason why, in all the people who were punished in this operation, you say the commander wasn't?
He was given a Category F, which is a formal counseling.
Okay, all right. So in your exam of this, or review of it, was there a look at what the protocol or procedure is on overwatch of the commander for issuances and service of search warrants under his command? I mean, is there a protocol that they followed or didn't follow when it came to reviewing the search warrants?
Yeah, he didn't review the search warrant. The commander didn't review the search warrant. The search warrant was supposed to be reviewed by the lieutenant. And it seems like the lieutenant didn't do a good job at that. He left it up to the sergeant.
So did the commander say, take any responsibility for not supervising the lieutenant in review of the search warrant?
I don't have an answer for that. I don't know.
Yeah, it just seems to me, this is just, from what I've read from this case, it just seems that, there needs to be accountability up and down the chain if there's going to be accountability at all.
Well, what I would say is that it seems like this whole thing started, it was a snowball effect, that the commander had information that the officer was not prepared, that he did not know how to do this, that he was not doing his job, and he shouldn't have been on this DPU unit in the first place because he wasn't properly trained to do it, and he was new. And so he knew that, but he continued to allow that officer to be in this unit when he had clear indication, not only just he had clear indication by the people that were supervising the officer. He had multiple instances where they were telling him that this officer should not be in this particular unit. He was not ready for that type of work, and he didn't do anything about it.
He admitted that he realized he was not capable. He left him in the position.
Well, he made some assertion to that, yes.
Okay. Okay. No, I have a lot of other comments about it, but it's just.
Well, you have time. You can talk about it if you want.
No, I have drafted served, managed hundreds of search warrants, hundreds. There is no margin for error with search warrants. You cannot make mistakes with search warrants.
That's correct.
Atlanta did it a few years ago where they killed a woman in a wrong address search warrant, and some of those officers went to prison for it. The Breonna Taylor case in Louisville is a good example of a complete disaster in serving search warrants. I hope that the department reviews the commander's responsibilities of oversight of search warrants, considering, nothing deadly happened in this, but it certainly could have. It is the possibility of what could have happened here. And again, if you're looking at accountability, it doesn't stop with the detail sergeant or the offense on the search warrant. It goes all the way up to the people responsible, all the way to the top, and that's in the chain of command. So I hope they're looking at this report with that eye for the future.
Well, I think the thing that the board should take into consideration that everyone received very lengthy, harsh, not really harsh, but discipline appropriate for the issue, whereas this commander received a formal counseling.
Judge Brown and then Mr. Kemmelgooch.
Well, I don't disagree with the punishments going up the line. I do disagree with the commander situation. They came down on the lieutenant very hard, and the lieutenant made a mistake by relying on the sergeants, but he didn't have any indication that the sergeants were deficient. But the commander apparently violated protocol on appointing this officer to the position. He ignored repeated efforts that he wasn't cutting it and was causing serious problems, and he did nothing about that. My view on that is that he should be moved up to a Category E and given a 2-day suspension. I mean, they demoted the lieutenant, to me, the commander is the ultimate responsibility. In the military, the commander is responsible for everything that his unit does or does not do. And he had not just, sometimes you just don't know, but he had specific repeated warnings that this officer wasn't cutting it, and he did absolutely nothing about it. I would recommend moving that up to a Category E and a 2-day suspension.
And I want to add something. At the time, only sergeants were required for the search, to answer your question, Mr. Nguyen, required for the search warrant application. But in this case, the lieutenant was the person that was dealing with this because the commander created a 2-man unit or 2-man units without sergeants. And so after this, the chief of police changed the policy to require the lieutenant be the person that approves those search warrants.
Yeah, I still think when you look at the punishment given to the lieutenant as opposed to the commander, it's disproportionate. The commander has gotten a free skate.
I would agree with that.
Mr. Kemmelgooch.
In a build upon what Judge Brown just mentioned, I was in a similar place, looking at the lieutenant getting 10 days, sergeant getting 30 days, and then Officer 2 getting 20 days, which no one got less than 10 days of this being suspended for this horrific event. I'm curious if how board members would feel about actually increasing the 2-day suspension to something that is closer to the 10-day. And the reason why I'm saying that is because all of these folks have responsibility in this horrendous event. And I think if we're going to root out the systemic violence that is inherently inside of MNPD, we're going to have to set the conditions where this type of thing just does not happen. So I would be curious on what board members think about actually going a little bit farther and actually making it where the commander, who actually didn't receive any days, actually gets closer to what everyone else received.
Mr. Hayes.
I wanted to address, it looks like
when I look at root cause, I mean, there were a number of things that went wrong, but this MDHA tenant list, that was really one of the problem areas. And I do feel the officers should have looked a little bit more to make sure that was correct. But it seems like MDHA has some responsibility there too. I mean, this is a government agency, and you're telling me that their lists are not up to date. And I didn't know if there was any type of communication with them to say there's something that needs to happen there. But yeah, I do agree that the commander should probably get something a little bit closer to what the other officers got.
The executive director's recommendation is a 2-day suspension as a Category E offense. Is that what the board wants to approve? You can make a motion to do that or to...
I would so move.
Thank you, Judge Brown. Any second? Guess we need a second on the motion.
I'll second the motion.
Thank you, Mr. Nguyen. Any focused discussion on that? Mr. Kamal-Gooch.
I want to just appeal to my other board members. This was a horrific event, and this took place, if I remember correctly, not too long after the country was in an uprising over the Breonna Taylor killing. So I would actually also want to mention that I would like to amend the set for a motion, if I can, I'm not sure. My Robert rules are not all the way clean. To actually increase the suspension, increase the offense category to a Category C, and increase the suspension to 6 days.
Thank you, Mr. Kamal-Gooch. Any more focused discussion on that, or how do we proceed if we want to amend the motion? Any guidance there? How do we proceed if we want to amend the motion?
Sorry, there's two motions, I guess, that have been made. One that has been seconded and there's been no vote on, and then there's also now a second motion.
Got it.
You can't, I don't think it would be proper to try to amend somebody else's motion that's been seconded. It's just going to be a separate motion with its own thing going on.
Thank you, Mr. Yoon. Mr. Goddard.
If Member Brown is agreeable to that, he can accept it. If not, then I agree with. But I have one other comment while we're at it. Director Fitchard, can you justify a C in 6 days based on what you see here? I appreciate your recommendation is something different, but if the board wants to go that far, is that something you could justify?
Now, what's your question? I'm sorry.
I'll try to ask it a little differently. Your recommendation is a lower category and number of days, and the proposed amendment would be a higher category of C in 6 days. I remember that right, Jamel? My question is, do you, as director, it's not your vote, but I just wanted your thoughts. Can you justify that if that is the mood of the board?
Well, when you say, can I justify it, are you talking about based on what's in the report contained, or is that what you're saying?
Yes.
Okay. I think that what's based in the report, I think it could be justified.
Okay.
I think it was an egregious act of and failure on the commander's ability to leave.
That's what I'm trying to, within the range of what would be reasonable based on all of this, does it fit that?
I think it would.
Yes, okay, thank you, that's very helpful. I will.
Mr. Brown.
Okay, I'm having a little trouble hearing Mr. Kamal-Gooch, but your motion was to increase the punishment for the officer. I want to be sure who you were saying to increase it for.
Commander.
So my suggestion, and this is if you accept this adjustment, is that we increase it for the commander, which was not punished at all. We increase the suspension from a Category E 2 days, which was recommended by the executive director, to a Category C at 6 days suspension to match or be very close and similar to what the lieutenant, the sergeant, and the officer received. And if I understand it right, Chair, since Judge Brown actually offered the motion, he can either accept the amendment and then we vote as motion is?
Right, if I accept the
Right.
amendment, then it would move forward to, for Mr. Campbell Gooch's amendment. I'm thinking. I think I'll accept it for the purpose of discussion.
Thank you, Mr. Brown. Mr. Nguyen.
This is related. I want you all to understand, I think most of you do, how devastating it is to be reduced in rank. It more than likely will have implications for the lifespan of all these officers, because they've got to go through promotional exams from here on out, which they may be denied because of I'm just explaining the process so you'll understand what's happening here, which also means their pay, which will equal hundreds of thousands of dollars. It'll also impact their pensions, which could impact hundreds of thousands of dollars in the future. So this is a major event inside any police department when you see demotions like this. It just shows the gravity of this case. I just want to make sure that, you know, we all understood that these line officers and supervisors really took a major blow on this case. And again, as I said earlier, there can't be any mistakes with search warrants because lives are in danger. You just cannot allow it to happen. And I think it's reflected in what the police department's done by demoting these officers. So I just want to make sure that was in the record.
And I'd like to add to that when you look at the discipline that happened here, the line officer received the harshest punishment, and then it went up. And I think that none of this would have happened if the commander had taken action when he had the opportunity to, not once, but multiple times. He had the opportunity to remove the officer who wasn't performing at the level that he should have, and he didn't even vet the officer, which is a process that he admits that he was supposed to do.
Dr. Hildreth.
Thank you. So I understand that we are on the motion that Judge Brown has accepted the amendment, so it is for a Category C, 6-day suspension. I will vote in favor of that motion with great reluctance, taking first what this incident meant to a member of our community, a woman who was in her home with her children, in public housing that is supposed to have extra protection. And then when we see the way that the dominoes fall, hardest on the lowest, when in the record of the recitation that, again, is in the public bit that you can see, I don't know what's in Director Fisher's file, but when we're looking day after day of create a unit with no SOP, no standing operating procedures, no training, no supervision, and on down the line before August 6th and after August 6th. And why am I naming August 6th? Because that is the day that the former police chief precipitously escalated the date of his retirement. We're talking about command. We're talking about command culture. We're talking about the rotten fruits of a bitter tree that fell on this woman and her family. My heart cannot take the thought that 6 days is a reach and is sufficient. But my mind and my sense of the only thing that holds us all together in hard times is this shared commitment to due process that Director Fitchard so eloquently articulated in the previous PRR, saying don't subvert process. I have to be content with that. So with the process of the investigation that's been brought before us, the facts upon which we are to make our decision, the grid that is available, the very thoughtful and insightful deliberation by my colleagues here, I speak in favor, reluctantly, of this motion. Thank you.
Mr. Campbell-Gooch. Mr. Abdullah.
I think that Dr. Hildreth said that way better than I would be able to say that. You know, the only thing I could think about doing, just listening to this, is a family who's in their home and to have this happen, and to have a commander or someone who is in high authority know that we have people that are not qualified but do nothing. I think that it deserves more than 2 days. So I, like Dr. Hildreth, I also am in favor of the 6 days.
Mr. Campbell-Gooch.
Thank you for that fruitful discussion. I am also in a place of reluctance with this, and I'm also holding all of the trauma and things that have happened to community members as a result of this situation. You know, we've received several complaints from officers executing illegal warrants. We've received several complaints about community members saying inappropriate search and seizure and their rights have been subverted. And I do think, and if I understand this correctly, Executive Director, a lot of this situation could have been avoided if the commander would have taken action with the information about Officer 2 before this even happened.
That's absolutely correct.
And with that said, just plainly, I'm not sure if 6 days is even enough. You know what I'm saying? If we have an incident like this, where if one person takes action, it prevents this type of thing from happening. I mean, I'm not sure if 10 days would be enough. It's just looking down on this thing. I wanted to say that, especially as the conversation here has moved in this direction. So I'll keep, I think, the 6 days just to make sure things aren't confusing. But after hearing board members' conversation, taking in more fully of the information, hearing more of what the executive director has said in response to other community members saying things that are sitting on this board, I would be moved, and I'm not making a motion, I would be moved that this person receives nothing less than 10 at this point. And that's just with all the information and the dialogue that we've had here.
Do we need to vote on the motion that's on the floor? So there's a motion on the floor for 6-day suspension category C offense. All in favor say aye. Maybe any opposed?
Nay.
And I vote aye. We're going to do a roll call vote. Mr. Nguyen?
Go back through that one more time. I thought we were passing on this in the 6th day. That's my understanding. It's not the vote, right?
It's the motion to accept the recommendations with an edit to make it a 6-day category C offense punishment there.
And that was Judge Brown's original motion, right?
It was the Judge Brown's amended motion.
Right.
Yes.
Okay.
So we're going to do a roll call vote. Your vote on that is?
I vote in favor of Judge Brown's motion.
Got it. Judge Brown?
Aye.
Ms. McCree? Nay. Mr. Goddard?
Nay.
Dr. Hildreth?
Nay.
I vote aye. Mr. Kamalgooch?
Nay.
Mr. Hayes?
Nay.
Mr. Abdullah? The motion does not pass. So Mr. Kamalgooch, do you have a new motion?
Yeah, I motion that we accept the PRR, but modify the recommended discipline to a Category B 10-day suspension.
I second that motion.
Thank you, Mr. Kamalgooch. Thank you, Ms. McCree. Any focused discussion on that?
I'm sorry, who was that to go to a category Bravo?
Category B and a 10-day suspension
For who?
for the commander.
Okay. So I'm sorry, I missed that part of it. Thank you.
If there's no focused discussion, I'll do a roll call vote. Mr. Nguyen?
No, I have no discussion.
Doing a roll call vote.
Oh, I'll vote in favor.
Okay. Judge Brown?
Aye.
Ms. McCree?
Aye.
Mr. Goddard?
Aye.
Dr. Hildreth?
Aye.
I vote aye. Mr. Kamalgooch?
Aye.
Mr. Hayes?
Aye.
Mr. Abdullah? So the motion passes to accept the PRR, but with the modification that the offense be escalated to a Category C 10-day suspension.
Bravo.
Exactly, Category B as in boy.
And that was for the commander.
For the commander.
For the commander.
Correct. Then we have finished the proposed resolution report. It's this time before 7. Now, if we have any public comment, yes.
Sorry. I have I wanted to read a victim impact statement from one of our complainants regarding her case. We have offered this opportunity for victims of complainants to speak on behalf, and this is something that is in our process that will now go along with the PRR to the chief of police. And what she says is, "Hello, Mr. Clausey. I, April Anderson, do not like this outcome that this officer has received, only suspended for 5 days. How come a person who's supposed to appear in court, that is the law, do not remember how many times he did appear in court? This officer is a liar under oath who is supposed to protect, serve, and be honest to this country, the United States of America. This officer should not be a supervisor. His rank should be taken away from him. He needs to learn how to be honest. I have appeared in court each time with a lawyer present. I am out of pocket paying for a lawyer and missing days from work. I felt like this would be all about the office and not was done wrong to me. If I didn't show for court, that would have been an arrest warrant out for me. He did miss more than 6 court days. I really do not appreciate this outcome." And this is in reference to case number 2020-030. And that is the conclusion of her statement.
Mr. Kamalgooch?
Thank you for that, reading that statement, Executive Director. My mind went to a process place. If maybe we should consider moving the victim impact statement to the piece where we actually are talking about the PRR when we're talking about it. I'm just thinking that as a process situation, we cannot legally do that, can we?
We can't take that into consideration.
And that is awful. So I'm just curious, is there a way that we can come by the office and see and read that type of impact statement before we even get here? Is that an option, or is that illegal as well?
I'm not sure if it's not permitted that you go see it, but when we vote on the PRR, we're voting on solely what is in the PRR and nothing else.
But okay, that makes sense. And if we're the community, well, I see the whole that is that if we're the community oversight board and we have a community member that comes before us about how the situation has impacted them, that would be a piece of their interview?
No. So what we decided was there was an opportunity in our original rules, and we had this conversation during a rules and bylaws meeting,
Right.
to move to having, instead of them, they could come in person and say what it was, and it would still be at the end of the process. So instead, we felt like, because I don't think that a lot of the commanders listen to our meetings like they should, so I would think that having this victim impact statement attached to the PRR when we present it to the chief, then he would understand the impact that it had on our community member.
Dr. Hildreth.
Thank you. So process clarification, when was that email received? It sounded like the person
So the email is, so the
the
victim impact statement is received after the notification that a PRR is going to go online and that we're going to do the process.
Thank you.
Judge Brown.
I guess I would ask our legal advisor to take a look at it. It does seem we've got the cart before the horse if we only hear about the impact statement after we voted on what we're doing. It seems to me, I agree with Mr. Campbell-Gooch, that I would like to have had that in voting on the report. Obviously, we've got to follow our own rules, but I would ask maybe that our legal advisor, if Daniel could see if there's some way that we could have that in. I mean, we got the sergeant's response to, about not showing up. We heard that, but we didn't hear the other side of that coin, and I would like to have heard both of those before I voted.
Mr. Goddard.
I was waiting on the chair. I think the rules, they need to be looked at. There's an answer when you read the text of the rules. My recollection is the rule was silent on that. My expectation actually was that they would be part of what was presented. But as I think back on it, I think we didn't address that one way or the other in the rules. So the board can make an interpretation without amending the rules, or we can amend the rules or whatever, but I think we do need to take a look at that. Thank you.
I think, Mr. Yoon, do you have any advice
Yes,
on
because
that?
I did review this in advance because I thought this might be important. You all might have questions about it. But yeah,
Good
the
job.
rules unfortunately currently do say that, first you get a complaint, second you get an interview with the officer, there's ongoing, and we can interview them as many times as we want. But at some point we do sort of close the investigation, we do the PRR report, and we tell them what our findings and recommendations are going to be. And so we also have this rule of presumption of correctness, and what can sometimes happen is people can add more information, along with perhaps a victim impact statement. So it was, I think, thoughtfully decided that we will do the victim impact statement after the board makes its decision, so that there's no risk that we don't follow our own rules. And what moves us in the victim impact statement is going to decide the outcome of your findings and recommendations and conclusions about the report versus what's said in that email or victim impact statement.
And I'd like to add to what Attorney Yoon is saying, is that during the course of the interview, you all have the opportunity to come and look at the complainant's statement. In the complainant's statement, they're expressing the same things. They may not know what the punishment is, but they're expressing how they felt about what was occurring with their encounter with the police.
Thank you, Director Fitchard. Any more discussion on that? If not, we had one public comment. Mr. Tucker?
Well, I hope y'all don't get tired of me showing, because I'm going to keep coming. This COB is not only a preference of the people, it is also a public statement of no confidence. So again, that's why your work to me is very, very important. But it's also the result of the city's CEO's, present and past, inability, refusal to manage, supervise the police and the police chief. So all along, we've been operating before this body with what you're now discovering. I hope that in your deliberation that you don't get so caught up, because you are studious and you are trying to find fairness, but to also realize that this is the exposure of a much larger issue. For some of you who know the city of Nashville, the Office of OPA is the result of a compromise doing a call for a COB back in the 90s. Kenitha Sawyers was its first director, who was run out by the police. Its present director, Kathy Morante, ended up suddenly, and it's all of this is in the newspaper, withheld evidence knowingly, willfully, according to Judge Cheryl Blackburn in her court findings, that resulted in a young black man being sentenced to 19 years in jail for a murder that she knew that he did not commit. The chief of police at that time, Anderson, writes a long piece that, again, is available on the web everywhere, talking about how great of an addition she is to the office of OPA. When I read this particular report of D 2020-005, which I was personally connected with, the young woman called me the morning that it happened. And I read the order from the office that the department finds that her rights were not violated. That to me is egregious. Absent you, that's what we would have had to live with. Absent what you did, going through all your munitions here, we would have lived with that, and we all know that the city dodged a bullet that could have ended horribly wrong. To add insult to injury, I'm there that morning. A group of officers show up with a load of groceries. And the woman says, I don't want your groceries, and they leave them anyway. It wasn't until I called Commander Green, who was over the South Precinct at the time, and demanded that if he don't get them, I'm going to put them in my car and dump them in the parking lot up at the South Precinct. Again, the city, even in what you're doing now, as you submit this to the chief, he still gets to look over this. He still gets to make a decision. The city wanted oversight. That's what the vote was. After all your deliberation, the chief ultimately gets to make the final decision after he ran through and did what he did that you find to be inadequate. And I find it to be hurtful, but also encouraging. You all are encouraging, but it's hurtful that the people of Nashville still have not gotten what they want. Kathy Morante is not a person that the community trusts or will ever trust. This investigation further proves this. This body and some derivative of it ought to be in charge of investigating all of it, because the police department is incapable. This city has lived under the tyranny of the blue line forever. And while I understand what you are saying about trauma, Mr. Wynn, I need some consideration for my own trauma. At 61 years old, I suffer from police-induced PTSD right now. My son does too. I need some consideration for that. You're almost there, but this is not what I thought it would be, and it's not what I hope it will ultimately be. Absent you, think about all that you've looked at, what would have happened and what would have been okay. Chief Drake's response to this incident was a political one because it got blown up all over social media, so he had to step in. And rapidly, he didn't do any investigation, he demoted some folks, fired some folks, but he did what he felt he had to do to answer the public's outcry over this. But this is a procedural issue. This is a command issue. This is part of the systemic problems that are alive and active right now in the MMPD. This is the problem, that the command structure breaks down. I read the report. There was a lieutenant who said, this is not a good idea. He said, I don't operate on stale evidence. Stale evidence is anything over 72 hours for me. And it appears from reading the report, he got pushed out of the whole investigation. So it's not that in my criticism of the police department that there are not good police. That lieutenant is a good police. But that lieutenant got pushed to the side when he brought up the issue about why we should not move forward with this. And it went all the way up the chain again, back down from the commander, and they went and did this. And the woman still to this day suffers from the impact of that. She says that when police pull up on her, she feel like she gotta pee.
Mr. Nguyen.
Yeah, thank you, and thank you for your comments. And please don't think that I've ignored your trauma. I'm very sorry for your trauma. Believe me, and I am.
I don't, Mr. Nguyen.
Yeah.
I was just offering an alternative. I listened to your deliberations,
Right.
and I appreciate what you're doing.
Thank you. No, I want to acknowledge that I understand community trauma and exactly what it is, and what communities in Nashville have suffered from being over-policed and underprotected. I completely understand that. That's my whole philosophy. I'm a procedural justice person. So I think, my feeling about all of that is with me, and it'll always be with me when I make decisions on this board about holding people in government accountable for their work, because, we pay them their salary. We should expect no less. But thank you for your comments, and I just want to make sure that I never would diminish your trauma and any experience you had with the police in the past. And it's one of the reasons I got on this board, to make sure that we don't have any more trauma. So thank you.
Thank you, Mr. Nguyen. With that, I'll take a motion to adjourn. Mr. Hayes? Wait.
I just wanted to say thank Pastor Tucker for his comments, and I did want to just clarify that the reason the chief gets to make that comment.
Thank you. Is there a motion to adjourn?
So moved.
Second.
Thank you, Mr. Abdullah. All in favor, say aye. Thank you, everyone.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.